Okay, we are now in week 8 of Wills and Estates. We're going to be doing chapter 6 of your book, which is now we're taking everything that we've learned. We've gotten all of our information from our client interview. We know what we're going to put together. We have all of our facts. Now what do we do? Well, we're going to do our final draft and present it to our client, and then have our client execute the will, which will, because we know the rules, be a valid last will and testament. Okay? Now, there are certain parts of a last will and testament that must be in there. Okay? There is a checklist on page 187, and we're going to go through all of those. Some of them we're not going to use, for instance, where we're going to have a personal representative or a guardian or a simultaneous death clause. We might not use that in all of our last will and testaments, but pretty much everything else we do. In addition, we are going to do some other documentation that will help our client later on, and those are documents that are not in the last will and testament. That's what this chapter covers. We're going to do those documents that are listed on page 188 of your book as outside of the last will and testament next module. This is a big chapter and there's a lot in here, so we're going to split it in half. So when it comes to a self-proving affidavit clause, a letters of instruction, power of attorney, living will, medical power of attorney, and memorandum of digital assets, we're going to do that in our next module. For this lecture and this module, we're only going to be doing the first half of the chapter, which is how do you know you've hit everything in your last will and testament? Okay? So we're going to start with, gosh, your book doesn't, oh, it does, okay. Yeah, the exordium clause. Exordium is spelled E-X-O-R-D-I-U-M, an exordium clause. It identifies who's writing this will, who's the maker of this will, and states their intent. So a typical exordium clause will be, I, Diane Hetson, and my address, being of sound mind and body and not acting under undue influence of any person whomsoever, do make, publish, and declare this document to be my last will and testament. I hereby cancel, revoke, and annul all former wills and testaments or codicils made by me. Now, we've already learned that if I draft a will today, and I did one 2 years ago, my mere act of drafting a new last will and testament revokes the old one, but it doesn't hurt. It doesn't hurt to put it in there. Okay? No misunderstandings, no ambiguity. You're dead. You can't explain this stuff. Right? If someone has a question, you're not around. So you want to use the most clear, unambiguous, plain language possible. That's a sample exordium clause. It meets that requirement of intent. Remember we talked about it? And the fact that we're not doing this under any duress. Those are important. Remember, those components of a valid will, this meets that component. Okay? Now, a general revocation clause can be included, and that's what we just talked about. That's what the I hereby cancel, revoke, and annul all former wills and testaments or codicils made by me. That is a general revocation clause. You don't have to have it. You don't. But, again, why not? Why should you not put it in there? If some smarty pants who Googles, hey, how can I contest this will? Hey, they didn't revoke this old one and I was supposed to get a bunch of stuff in the old one. Now it's completely clear. There's no question. Okay? Next, typically, you'll see some kind of a clause that says, hey, pay my funeral expenses. whatever it costs to bury me, take that money out of my estate to bury it. Now, some states don't like that because it kind of messes up money calculations. What a lot of people will do is they will get an insurance policy while they're still alive, and that insurance policy will be for the express purpose of burial, and the beneficiary, the entity that gets paid upon my death, if I'm the one who has that insurance policy, is the funeral home. The funeral home will get typically $10,000. It's typically a $10,000 life insurance policy. And the funeral home will be named as the beneficiary so that when I die, the funeral home doesn't bug anybody for money. Now, another thing that people will do is they'll pre-plan their wedding. Sorry, my daughter's getting married. I got wedding on the brain. Will pre-plan their funeral. It's a really nice thing to do. You pay everything off, and then there's no question, no bills, nothing. It's fantastic. So you do one of those two things if you're really planning ahead. And if you go to an attorney's office, or if you're working in an attorney's office, you're going to recommend that your client do that. Okay? But let's say that the funeral costs $10,500 and your insurance policy is only for $10,000. Okay. You are making things perfectly clear. I direct my personal representative, hereinafter named, to pay all my just debts, estate administration and taxes, expenses of my last illness, funeral, and burial out of my estate as soon as possible after my death. Now, I'm going to take one issue with this particular clause, where it says I'm going to pay all my just debts. I want my legal representative, my executor of my estate, to pay all my just debts. When I was in law school, had a professor, Professor Dewey, and he was a hoot. And he taught me probate law. And he brought in all these books. He walked in one day with all these books. And we were learning about what goes in a valid will. And he read a clause just like this. And he goes, "Garbage!" And he threw the book across the room. And he did that like 5 more times with 5 more books. He goes, "That should say my legal debts. My just debts means, hey, somebody used to bring the decedent breakfast." A just debt, a moral debt, is one where you feel an obligation to pay. You may not be legally obligated to, but you sort of feel morally obligated. Okay, you're now raping the estate as the fiduciary, the legal representative, the executor of the estate. No bueno. Don't do it. Really, it's your legal debts that need to be paid, and that language should be in there because remember, we've talked about ambiguous language and debts. Who wants to fart around arguing about what just means? Doesn't make sense, does it? So this debt payment clause, which includes your funeral, probably should just say my legal debts. Okay? All right. Instructions for funeral and burial. A lot of people put that into their last will and testament. Probably already buried. You're probably already buried by the time they get to the will. We're going to talk about letters of instruction in our next module, where you clarify all of that. You can put instructions for funeral and burial in there for one reason. If you're going to give a copy of your last will and testament to all of your children, if you're going to give a copy to people who are you presumably think are going to be alive and the ones who are going to actually carry out your burial, so that everybody knows what you want ahead of time. You know, I'm a big proponent of kitchen table talks. And I think that when you do your last will and testament, you need to have a kitchen table talk with your children, your spouse, your parents, whomever, and everybody gets a copy. That's why you would put instructions for your burial and funeral, right? You end up with a situation lots of times where someone's faith may say, hey, no cremation. Or some families will want the body transferred to another state to be buried in a family plot. Okay? Maybe that's not what the decedent wants. And to avoid a problem with everybody in the family fighting about it, just put it in the last will and testament. You're probably either cremated or buried by the time everybody gets to the last will and testament, unless everybody's got a copy of it already and they're like, oh, this is what they wanted. Mom wanted to be buried in a red dress and high heels. Or Dad said, don't you dare put a suit on me. You better put my Pittsburgh Steelers stuff on my body when you put me in the ground. Right? It takes a little bit of the pain away for the people who are left behind, if you're very clear. And by being very clear, what I mean is put it in and give everybody a copy so there's no question. This is what Mom, this is what Dad, this is what Uncle Sam wanted. Okay? All right. The next thing that you're going to do is you're going to, and this does not, your book doesn't actually do this in the right order. I'm just going to tell you. You need to name your executor. Okay? On page 199 and 198, it says appointment of personal representative. Your personal representative is the person who is still on this earth while you're gone. Your executor is who you trust to make sure that what's in your last will and testament gets carried out. Okay? That's your executor, your personal representative. If you die without a will, if you die intestate, you don't get the chance to say who this is going to be, and the court appoints an administrator. Okay? And there are statutory rules about what an administrator can do. And you don't have any say in it. You know why? Because you didn't do a will. Okay? So when you do a last will and testament, you appoint a personal representative. That personal representative, that executor, is your fiduciary. A fiduciary. Fiduciary comes from the Latin word fi. F-I. Means faithful. Okay? Trusted. A fiduciary is held to a very high standard. Now, before you appoint somebody to be an executor, you probably want to talk to them while you're still on this earth. Because being an executor is a heck of a lot of work, and there can be criminal liability if you do something wrong. Okay, so why would anyone want to be an executor? Well, it's an honor also. It's an honor. It's a lot of work. But it's also an honor because you're trusted enough by the decedent to carry things out. Now, an executor is given certain statutory authorities. One of them in every state in the Union is to hire a lawyer that the estate is going to pay for. Huge. It takes a ton of the burden off of the executor. They won't miss something. And if something is missed, it's a buffer between the executor and criminal liability. I'm doing what my lawyer told me to do. See what it said in the letter? Okay? So everybody hires a lawyer. For every estate that's worth anything, they hire a lawyer. Okay? And then you can give additional specific authority to the executor. Like, I give authority to my executor to sell property, right? To pay my debts. I give authority to my executor to use his or her discretion about where to donate something. You can do things like that. Not recommended to give the executor a ton of discretion. The statutes for probate law will go ahead and give the executor the authority that he or she needs, or it can be an entity too, we'll talk about that in a minute, to get done what they need to get done. Okay? So who do you typically appoint? Well, husbands and wives typically appoint each other. Or if you're older, maybe your children, one who, is particularly responsible. Okay? And remember, we always have to have a backup. We always got to have a backup. So let's say that I want Mr. Hetson to be my executor and he passes away before me or at the same time as me. What do we do? Now we don't have an executor. Okay? The court will name somebody, but it's basically going to be an administrator, and you don't have any say about it. You don't know who that fiduciary is going to be. So you pick a runner-up. And you can even pick a second runner-up. The first runner-up usually is another person. The second runner-up typically will be the trust department of a bank. Why? Banks don't go away. Now, they get bought out, so you could say to PNC Bank and its successor in interest. That's how you say whoever bought out PNC Bank. Okay? But their trust department, this is what they do. Now, they're going to charge money. And executors are entitled to get paid. It's a percentage of the value of your estate. Okay? If it's not a big estate, oh well, they get a little something. If it's your daughter, your son, your nephew, they're typically not going to get paid. They're not going to choose to get paid. But a bank, they're going to choose to get paid. So you should keep that in mind. Okay? So after you name your executor, then you start saying who gets what. Right? My prized Pez dispenser collection goes to somebody. And if they don't want it, the next person gets it. Okay? Even when we're naming beneficiaries, back up. I may think that my nephew would love my Pez dispenser collection. And you'll just have to guess whether I have one or not. Okay? So maybe I thought my nephew would, but my nephew's wife says, if you bring those things into my house, we're getting a divorce. So my nephew says, I may like those, but I like being married more, so I'm not going to take that. So then what happens to it? Well, there's a runner-up. And if the runner-up doesn't want it, we've got a residuary clause, which we're going to talk about. Okay? So all our specific devises, our specific bequests are going to go in this section. Okay? Next, we're going to do a residual clause. The residual clause is that section that says, for all the stuff that's left over that nobody wants, this is what I want done with it. Now, there's three basic kinds of residuary clauses. The first is where you will direct your executor, sell anything that's left, and divide the money up amongst these people or give it to the specific charity. Or you can say, all of my stuff I would like then donated to this specific charity. Why? Because just like trust departments of banks, charities generally don't go away. This way, everything gets disposed of. Because anything that's not disposed of, hope you remember this word, escheat, my least favorite things in the world because it has the word cheat right in it. ES plus cheat equals escheat, which means the state comes in and grabs anything that's left. If you don't have a residual clause or a residuary clause, however you want to call it, where all the leftovers go and then are dispersed, either sold and dispersed or just given to, outright given to a charity, you're in trouble. Because then the state comes in and cheats that charity out of and sucks it up. And then they'll sell it and they'll keep the money, for all the wonderful things that the state does. Okay? So residuary clauses are a really big part of the deal. Okay? If we have children, we need to appoint a guardian for our children. Now, there are two different kinds of guardians. There's one over a person and one over property. They can be two different people. The one over person is the one who is going to be the guardian over the child, gets them up for breakfast, feeds them to breakfast, gets them to school, puts them to bed at night, That's the guardian over the person. They're residents. They will have the child live with them. Okay? Guardian over the property will take care of all the finances. Now, you can combine them, or they can be two separate entities. Maybe I think that my sister would be great raising my children. But, she's filed for bankruptcy. She's not great with money. I'm not really crazy about this. Maybe I want my brother to be guardian of the estate or the property. Okay? Remember, estate means your stuff. So guardian of the estate or guardian of the property, maybe my brother's going to do that. My brother's going to give money to my sister to help raise the children, and it'll be a nice family affair. Or maybe I just have a lot of investments, and I would prefer to have the trust department of a bank take care of all of that and take all of that stress off of my sister who's going to raise my children. And then the bank will make sure that my sister has money to raise the children. You can put all of that in your last will and testament, and you must. Otherwise, what happens is a guy or a gal in a robe that you've never met is going to decide what happens to your children. Not the best. Okay. If you're married and you have crafted your wills so that, and this is very common, that if I die first, everything goes to my husband. If my husband dies first, everything goes to me. That's great, except what if we die at the same time? So you need to have what's called a simultaneous death clause if you have those kinds of issues. Now, simultaneous is one of these words where we're going to give it a new definition. Simultaneous can mean at the same time or within a certain time period. So if we die within 7 days of one another, there will be a presumption that I died first. Or if we die at the same time or within 7 days of one another, there will be a presumption that I die first or that my husband dies first. We are going to create a legal fiction. Why is that? Well, we presumably have crafted our last will and testament so that everything runs through the estate where the least taxes are going to be owed. Okay? So a simultaneous death clause where you can tell the world, and the court will honor it, whoever, even if we die within, usually it's within 7 to 14 days, and not really 14 days is kind of the outside of it, then we're going to presume that one of the spouses died first. And again, that is to maximize whatever kind of estate planning has been done with respect to taxes, to make sure that the least amount of taxes get paid. Okay? Now, we can also create what's called a testamentary trust. And when we were talking about the guardians for the children, typically this is what you will do. You will set up a testamentary trust. Or if you have a lot of things that you think are going to be taxed tremendously, you will set up a testamentary trust. Now, I want you to just keep that in your brain. We're not even going to get into it now because in a few weeks we're going to be doing trusts. Trusts are very complex instruments that are a legal fiction where we can have somebody take care of our stuff, but they don't own it. And they can give the benefit of the stuff in the trust to other people. And the people who are getting the benefit don't own it either. We're basically creating a fictitious entity that owns itself. And that's kind of weird, but that's what it is. So just remember that you may make a testamentary trust, create it in your last will and testament. Okay? The next thing you're going to put in there is a testimonium clause. Testimonium clause is, hey, I have freely signed this. Not under any duress. Nobody has made me do this. Okay? Now, one thing that you also want to put in here, and I'm not seeing it here in your textbook, is, let me just look here real quick, an in terrorem clause. In terrorem clause generally goes somewhere around your testimonium clause. And an in terrorem clause basically is where you're telling your beneficiaries, hey, if you contest this will, you get nothing. Leave everything the way it is. Do not try and squeeze anything more out by filing a will contest. If you do, you get bupkis. Okay, that's called an in terrorem. Terror, right, with orum on the end of it, O-R-U-M. It's to scare people into backing off. Okay, so when you do your testimonium clause, most of the time it'll either be a separate clause right before the testimonial clause or included as part of the testimonial clause. Okay? After that, there's the testator's signature. And we've talked about what is a valid signature. It can be an X. It can be scribbled. That's okay. If that's all the testator is able to do at the time of the will, then that's all they can do. Okay? But again, it cannot be under duress. It can't be under fraud. That's the big part of it. Okay? And then we have the attestation clause. That's where the witnesses say, yep, I know what I'm doing. I saw the testator knew what they were doing, they read it, they initialed every page, and they signed it. And I understand that I could be called as a witness. Okay. Then there's the signature. Okay? Now, there is a sample worksheet for drafting a will without digital assets, and we'll talk about digital assets in a little bit too. You can read through it. The worksheet is on page 209 and 210. Then the will itself starts on 212. If we were in the classroom, I would have had you label this. I would have printed this out and not had the different sections identified on here. They're on here. You can understand where each part goes. You can familiarize yourself with it. Again, there are software programs, again, not Google, not Facebook, not Staples, but programs that are put out by whoever does the software for the probate court. And there will be samples that you can not just fill in the blanks, but they'll have the checklist. The checklist will correspond with the form, and then you go through and you modify it. Okay? All right, so those are all the components that go into a valid will. Next module, just to tease, we're going to go into all the things that you want to have your client draft that go along with the last will and testament and are just as important. Okay? So that's it for this part of the chapter. Please do your assignments, do your discussion, and again, if you have any questions, you need to reach me, please email, text me, or call me. Okay? Thanks so much.